Congratulations.
Here's your graduation.
That's on my fault. I pinched.
Everybody gets pinched, but you did it right. You told them nothing, and they got nothing.
I thought you'd be mad.
Man, I'm not mad. I'm proud of you. You took your first pinch like a man, and you learned the two greatest things in life.
Well,
Look at me. Never rat on your friends, and always keep your mouth shut.
I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And yesterday, we kind of took the day off. Me and the wife went out and took a little boat out. We live about 15 minutes from one of the best crappie fishing lakes around because I missed the white bass run. But we went out yesterday and had a good time and just relaxed, did some fishing, and now I'm back on it. But there's been some things that have happened, and what I want to do is I want to give you an update. And you know me, I don't like to just pop stuff up and go, well, you looky here, we've got this happening, what's going on? I like to really think these things out and do a little bit of research before I, post a video to give you an update on things. So there's been some action in the case, and I'm going to talk about that action that's going on, but I'm going to give you some possible reasons for that action. And it's not really difficult to figure out what's going on as it relates to it, but you kind of gotta think it out because everything is strategic, especially from the defense's perspective. They are very strategic. As I showed you in the video the other day, when Massow says, we are very calculated and we are very calculated in everything that we do. Well, that lets you know that they think several steps ahead before they do anything. So, and one of the things that I pointed out was the fact that because of the recent Dateline issue and the things that are coming up around that, I firmly believe, and based on what the judge said in court, it's obvious that when the defense submitted their offer of proof, their proffer, that they included all the allegations, but they didn't include the actual proof that they have. And that's why the judge said, well, I'd like to see, the proof that you have. Well, now we've got a few new court docs that have come up, and one of those is the defense filing a motion to continue. Now, I do not believe in any way it's a motion to continue the trial. All right, so some people are going to try to jump on that and go, oh, look, they're trying to extend it out. No, they want that trial to start when it starts. But from a strategic standpoint, the defense, and this was mentioned in the limine hearing, and it's also mentioned in their filings for limine when it comes to alternate perpetrator. And they want to get as close to court as they can before they really give the offer of proof. The judge kind of was trying to hold their feet to the fire by saying, hey, we want it now before trial. And, it's something they were going to have to do. But then when the fiasco came out with Dateline, I believe it was their opportunity for them to try to push that out because they want to push it out as close to trial as they can. So now we've got a motion to continue by the defense, but we also have a motion to exceed the page limit, or I'll read it to you here in a minute. It's one of those motions where they're going to exceed how many things they can put into a motion. So the defense has a big motion coming. And I don't think it takes a genius to figure out what that motion is. And I've told you for a while now that the defense is going to figure out a way to get rid of this death penalty before the trial happens so they can seat a non-death qualified jury so they'll have a more open mind when it comes to, the actual case. Because when you have to ask that jury those extra questions of could you, convict somebody and send him to death, then it puts a certain type of person on that jury. And they know that, and they've said it 100 times in court, and this has been a big contention the whole way. So now we've got those two filings, which I'll talk about, but then we have another filing, and it is a special hearing on May 21st. And it doesn't take a genius to figure out what this special hearing is about. About a week or two ago, I did a video after Mr. G went on to a few of those online channels, one of them, pretty major, and he disclosed a lot of things in those interviews. And I immediately made a video and I said, you know what? The defense needs to file a motion for discovery because he's saying that he's got information from his investigators. I don't know if it's been turned over to the defense. And then the other things that he kept bringing up, if you pay close attention to those interviews, was most of those things that came out on the Dateline episode were things that he had talked about in those interviews. He had left a comment on one of my videos talking about, and we all heard it, and he put it out there to some of those other Gilcher content creators. But he said that, the thing that's going to get him is just Google searches. I mean, that was a comment on my video. And one thing he said, though, that turned out not to be accurate was that Kohberger had Google searched the Moscow unalivings the morning of the unalivings. Well, that didn't happen. He Googled that according to Dateline 3 days after. But that was the kind of things that he was spreading out there. I mean, he was talking about, how he was Googling Ted Bundy. He was talking about all those things that Dateline released. And then when you listen to the Dateline, they tell you they've got a couple of sources close to the investigation. Well, I mean, I don't think it takes a genius to figure out that a lot of that information was being leaked, in my humble opinion, by Mr. G. But then they got to some other source inside to verify what he was saying, and they got additional information. And one thing I could never figure out is I know we heard early on that I think it was Olivia had got the 1112 King Road footage before even law enforcement did. And that's how they got some of those pictures out to the public in the beginning. Well, if she had that footage, then that means she would have the footage of what was released to Dateline as well, as far as the car footage, because you can bet that the car footage and the search history of Kohberger's phone and those screenshots, that was the big bombshell stuff that was released that wasn't supposed to be released. And I'll talk more about those videos of that car later, because what they did release is very suspicious. Very suspicious. And as I dive so deep into those things, it's kind of scrambling my scrambled egg brain right now. But anyway, so we're going to try to focus on what the gist is on this one. And that's what that hearing is about. I'm going to show you some things around that hearing that's coming up on May 21st, show you why it's probably happening, and I'm going to give you my opinion on what the defense's strategy is from that. So let's jump into it. All right, first things first, we're going to jump into the case summary, and I pulled this up this morning, and you can see since that pretrial conference, the judge has sealed defendant's offer of proof for the alternative perpetrators, and again, this was the proffer that the defense submitted. They didn't actually include the offer of proof yet. Document and records hold order, that's for the investigation into the leak. Then we got the document and records hold order for the defense, which was just kind of a mirror copy of what the judge gave to the prosecution. And then we got our court minutes. But then immediately we've got an order regarding the May 15 hearing, and I don't believe there was much to that. Wait a second here. All right. So, but then the next day, so you got to look at the progression of this and how fast it happened. The next day, right, we get the pretrial conference. He issues some orders, holding records. And then the next day on May 16th, he issues a notice of a hearing, discussions regarding role of victims. Why do you think this thing popped up? Well, we'll talk about that. But then, just a few days later, we get these motions from the defense. Number one is defense's motion for leave to exceed the page limit. That means that they're going to have a very large motion that they're filing. But they also filed a motion to continue. And I'm willing to bet that this motion to continue is going to be a motion to continue this hearing that's scheduled on June 18th, or at the very least, a motion to continue when the judge told the defense that they had to enter their offer of proof. And I can't remember exactly the date on that, but he had only given them like a week from the pretrial conference to enter that offer of proof. They might have been 2 weeks. I think he gave them either a week or 2 weeks. Then he gave the prosecution 2 weeks to respond to that. Then the hearing would be scheduled on the 18th. So I think it was more like a week. But anyways, you can bet this motion to continue is for them to continue the date of them having to submit their proffer for their offer of proof. And they're doing that in lieu of the motion for leave to exceed page limit on something they're about to file. And you can bet it has something to do, not trying to be clear as mud, but something to do with waiting for what the outcome is of this May 21st hearing, where they're going to be having a discussion regarding the role of the victims. So let's dive a little deeper into that one. And okay, this is the order for sealing the offer of proof. Okay, so right here is the judge's order for the notice of the hearing regarding the role of victims. And that one's going to be sealed. They're not going to let us hear that one, but everything we need to know is in this notice. May 21st, 2025 at 10 a.m., Stephen Hippler. This hearing will be held via Zoom. And what are they going to be discussing in this thing? But look when it was dated. May 15th, 2025. So May 15th, 2025, the day of the pretrial conference where they had those discussions about the leaks. Now, who have they sent these certified copies to? William Wofford Thompson Jr., the lead prosecutor. Jeffrey Nye, Special Assistant Attorney General, the supplemental prosecutor. Josh Hurwitz, Mr. AK himself, the Special Deputy Prosecuting Attorney. Senior Deputy Prosecuting Attorney Ashley Jennings, who will no longer have a career when this case is over, in my humble opinion. And then Madison Allen, Special Assistant Attorney General, and she is brought on specifically for jury selection. That is her specialty. But down here we've got Miss Ann Taylor, Miss Massoff, Bck'S Barlow, their supplemental attorney, Mr. Logsden, and then we got Shannon Gray from the shannongraylaw.org. Now, we don't see the attorneys here for the Chapins. We don't see the attorneys here for the Mogans, the Kernodals, and we certainly don't see the attorneys here for Dylan or Bethany. Okay, so, and that's really the only victims that are in this case, right? And this is for role of victims. So the only one that they're bringing in is Shannon Gray, Mr. G's attorney. Now, when you go back to the beginning of this case, you'll see there was a lot of things in there about Shannon Gray. Last time that we really heard from him was when when they filed to try to get Ann Taylor to get removed from the case because they knew Ann Taylor knew something about the parents of these victims because she had represented them in the past. But anyway, so the fact that they got Shannon Gray on here and no other attorneys that are going to be present tells us that the reason for this hearing is for Mr. G. And since it was issued the day of that pretrial conference, well, you can bet that there's going to be some things discussed in this hearing with Mr. G and his attorney. Now, again, it doesn't take a genius to figure out with the videos that we've done the last couple of weeks about the leaks and what Mr. G was saying out there in those interviews. He's going to be they're going to talk to him about this. Plus, the other thing is Mr. G is the only family member that we know of that has been front and center out there pushing for death in this case. So when we look at roles of victims, it kind of tells us a little bit about what this could be, concerning. Now we know it's got to be concerning his leaks, but repercussions from his leaks, could that be one of the concerns? All right, so let's talk about this for just a second. In Idaho, if a victim violates a non-dissemination order, they may face penalties, including potential jail time and fines, according to Idaho law. The specific role of the victim in such a case would depend on the nature of the violation and the specific order in place. And let's see, elaboration. All right. These orders, often part of a broader protection order, prohibit the victims from sharing certain information. And then it goes on to say, such as details about the abuse, because a lot of times there's a non-dissemination order in an abuse case, or the proceedings with third parties. And violating a non-dissemination order can result in penalties, including jail time. A violation could lead to imprisonment for up to a year or a $5,000 fine. But when it talks about the victim's role, because that's what the hearing says, it says role of the victims. And in context of a violation, the victim may be required to attend court. They may be called to court to explain the violation and face potential sanctions. Well, when we see that there is a hearing that's scheduled for role of the victim, and we know that they just violated the non-dissemination order, this could be seriously what it's about. They might be called to court to explain the violation and face potential sanctions. Be subject to further restrictions. The court may modify or extend the non-dissemination order or even add other conditions to the existing order. Or have their case re-examined. If the violation is due to fear or coercion, the court may investigate further to ensure the victim's safety and well-being. Well, we know that's not it. But it's crucial for victims to understand the specific terms of the non-dissemination order as well as the potential consequences of violating it. They should also be aware of resources available to help them navigate the legal process and ensure safety. So, what could this thing be? Now, here's the other thing that needs to be considered. This is how big this is, folks. The victim deserves a voice in the criminal justice system, not only in hearings on the amount of restitution to be paid him or her, but also the offenses to be used as the basis for such restitution. The victim should have a right to participate in court hearings on dismissals, guilty pleas, and sentences. So, in a case such as this, if there is going to be any type of consideration given to a dismissal, which I don't think we would get a dismissal in this case, obviously, but also the sentences. For example, if the judge was considering removing the death penalty because of these leaks of the discovery that impedes Kohberger's right to a fair trial, then he absolutely has the right to remove the death penalty. And if he does that, he would bring in the most vocal person of the victim's family, which would be Mr. G, to discuss removing the death penalty with him, because as a victim, he has the right to participate in court hearings whenever they're talking about doing something like removing the death penalty. And here's the other thing that makes me want to really bring that up in this discussion. But now we get down to it. In Idaho, a non-dissemination order, gag order, protects evidence and trial information from being publicly released before a trial. If law enforcement violates this order by leaking evidence, it could lead to the suppression of that leaked evidence in court, and the defense might also argue for the removal of the death penalty if the leak significantly prejudices the jury or violates due process. If a judge finds that law enforcement violated a non-dissemination order by leaking evidence, that evidence could be deemed inadmissible in court. This is because the court may rule that the evidence was obtained or disclosed improperly, violating the defendant's right to a fair trial. But also, if the leak is deemed to have a significant prejudicial impact on the jury pool or violates the defendant's due process rights, the defense may argue for the removal of the death penalty as a possible punishment. This is because the death penalty is often reserved for the most heinous crimes, and a leak could cloud the juror's judgment and make them less likely to consider a lesser offense or lesser sentence. And the right to a fair trial is a cornerstone of the legal system. Leaking evidence before trial could create a hostile atmosphere and make it difficult for the defendant to get a fair hearing from an unbiased jury. So in conclusion, when you start to put everything together, the motion for a hearing discussing roles of victims, the fact that the non-dissemination order was obviously busted, and evidence was put out there to impede Bryan Kohberger's right to a fair trial, the judge adding additional jurors to the jury pool in that hearing. He said they're going to have 2 extra alternates now, and it's going to take a lot longer to seat that jury. It's going to cost the state of Idaho a lot of money. So he's acknowledging when he says that this leak had a big impact. He's also waiting for the defense's motion for him to assign a special prosecutor that he told the defense, hey, I'm waiting for that so we can get that going. And why is that? Because when a special prosecutor is assigned, if they're able to locate the source, which would be in law enforcement, it would all but guarantee the death penalty to be removed. But the investigation of a special prosecutor, it would take some time. So they're not going to find out if it was definitely law enforcement before the trial starts. So what do? They bring in Steve G for a role of the victims hearing. I believe during that hearing on May 21st, that they're going to point out the fact that Mr. G has been out there disclosing this evidence that wasn't supposed to be disclosed, busting that non-dissemination order that he clearly stated in his very first pretrial conference with them, that the non-dissemination order extends to the victims' families and their attorneys. So there's no doubt that Mr. G was under that order, and the judge is going to remind him of that in that court hearing, I believe. And the last thing is, whenever they're talking about removing a sentence such as a death penalty, then the victims, the role of the victims, they have a right to be party to those discussions. So I think it's twofold. They're going to bring Mr. G in, talk to him about his violation of the non-dissemination order, and have the discussion about removing the death penalty due to that. So in the end, if this non-dissemination order removes the death penalty from the Bryan Kohberger case, the most vocal, outspoken person about wanting the death penalty will actually have the most responsibility as it relates to removing the death penalty in the case. So the person that wants it the most would be responsible for having the death penalty removed in the end. But that's where I think we're at with all this. So I wanted to get that out to you, and I've got another one I'll be putting out this evening. I'm working on some really interesting stuff on this, and I know I keep getting 100 comments in there about, Outcast and Birdie. Look, Outcast, I like Outcast. He comments on my videos all the time. So I'm just no reason to even ask me about their work, because I'm not going to say anything, because I want those guys to do good. I noticed Birdie, he's even, he's got my troll that I, brought into existence. She's focusing on him right now. So that's good with me, but I'm not going to comment about any of their work. I think those are good guys. Please like and subscribe to this channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.